Have you ever wondered how a criminal case in South Africa actually works? From the moment a crime is reported all the way to a final verdict in court? Well, you've come to the right place. Today, we're unpacking that entire journey, creating a complete roadmap that's perfect for your studies. All right, so here's our game plan. We're going to start with the basic rules, then dive into everything that happens before the trial, then the main event, the trial itself, followed by what happens with the verdict and sentencing, and finally, we'll look at what options are left after the trial is over. Let's get into it.
Okay, first things first. Before we can start the journey, we have to know the rule book. So what exactly is criminal procedure?
Think of it like this. Criminal law is what tells you, hey, theft is a crime or assault is a crime. But criminal procedure, that's the how. It's the step-by-step instruction manual for the entire justice system. It's not about what is a crime, it's about how a person suspected of a crime is prosecuted, from start to finish.
So where do these rules come from? Well, they don't just pull them out of thin air. There are three main sources you need to know. The big one is the Criminal Procedure Act, or the CPA. Then you've got case law, which is really just a way of saying the decisions that judges have made in past cases. And underpinning everything, the most important source is the Constitution, especially Section 35, which guarantees fair trial rights for everyone. All right, let's move on. A huge part of the whole legal story happens long before anyone even sets foot in a courtroom. This is the pre-trial phase, and believe me, it is absolutely critical.
The pre-trial journey is where the entire foundation of the case gets built. Each of these steps is a crucial building block, so let's walk through them one by one.
Absolutely nothing happens until a crime is reported. This is the spark that lights the fuse. It can be the victim, or it could be any member of the public. So, imagine a phone gets snatched on a street in Cape Town, or a student sees a theft happen outside the UJ library. Whoever makes that report has just fired the starting gun for the entire process. Once that report is made, the police open a docket, which is basically the official case file. An investigating officer gets assigned and starts gathering evidence. The most important pieces of evidence at this point are usually sworn statements or affidavits from the victim and any eyewitnesses. Once the officer thinks there's enough evidence, the whole docket gets handed over to the Director of Public Prosecutions, the DPP.
Now, this slide is great for understanding who's who in the prosecution's team. The DPP gets the file and makes the big call on whether to prosecute. If it's a case for a lower court, like a magistrate's court, a public prosecutor will handle it. For more serious cases in the high court, a state advocate takes over, and the big boss over everyone is the national DPP. And this is a massive decision. A prosecutor can't just go with their gut feeling. They have to apply a very specific legal test to the evidence sitting in that docket. And that test has a Latin name, prima facie. It literally means at first sight. The easiest way to remember this for an exam is to think of it as the "is this case even worth it" test. The prosecutor looks at everything and asks, at first glance, is there enough evidence here that a reasonable person would believe a crime was committed and this person might be connected to it? If it's a yes, the case moves forward. If not, it stops right there. Okay, so we have a prima facie case. The state now needs to get the accused to court, and they have two main tools for this: an arrest or a summons. A summons is the preferred, less dramatic way. It's basically a formal notice telling you to show up to court on a certain date. An arrest is way more serious. It usually requires a warrant, and it's used when the state thinks it's necessary. Once arrested, a person must be brought to court within 48 hours.
So the accused is now at court. The first big issue to sort out is bail. The court has to decide whether to release them until their trial date. To do this, it weighs three key factors, all based on the interests of justice.
And here are those three core questions. Number one, will the accused actually show up for their trial, or are they a flight risk? Number two, is there a chance they'll commit another crime if they're released? And number three, will they try to interfere with witnesses or the investigation? The answers to these questions are what determine if bail is granted. And now we finally enter the courtroom. Everything up to this point has been preparation. The trial itself is split into two main stages. First, the trial on merit, which is all about guilt or innocence. And then, only if they're found guilty, do we move to the trial on sentence. The trial on merit follows a 5-act structure, which is a great way to remember it. Think of it like a play. It starts with the plea, then the state presents its case, then the defense has its turn, then come the closing arguments, and it all ends with the findings, or the verdict. Let's break it down.
So the trial starts when the charge is officially put to the accused and they enter their plea. If they plead not guilty, they usually get a chance to give a plea explanation, which sets out their side of the story. But here's a key detail. For a serious crime, a court won't just accept a guilty plea immediately. It has to question the accused to make sure they fully understand what they're pleading to. It's a safeguard.
This really gets to the heart of it. How is a case decided? It all comes down to a crucial concept called the burden of proof. And it's so important to understand that this burden is not the same for both sides.
Pay very close attention here, because this is the core principle of a fair trial. The state has to climb a mountain. Its burden is to prove guilt beyond a reasonable doubt. That is a very high standard. The defense, on the other hand, doesn't have to prove innocence. They just need to create a little hill of doubt by showing there's a reasonable possibility their version of events is true. This imbalance is what innocent until proven guilty is all about.
After all the evidence is in, we get to the climax. In step 4, both sides make their closing arguments, trying to persuade the court. Then, in step 5, the presiding officer, the judge or magistrate, weighs everything up, applies the law to the facts, and delivers the final verdict, guilty or not guilty.
But if the verdict is guilty, it's not over yet. Now we move into the second major phase of the trial on sentence, which is all about finding a just punishment.
During sentencing, the court has to weigh up the scales. On one side are mitigating factors, things that might lessen the sentence, like being a first-time offender. On the other side are aggravating factors, things that make the crime more severe, like its brutality. But there's also another way, a plea agreement, where both sides agree on a sentence beforehand. But, and this is key, a judge still has to approve it to make sure it's fair.
Okay, even after the sentence is handed down, the legal road might not be at its end. If someone believes an injustice happened, there are two final paths available: appeal and review. Now, this is a classic exam question, so listen carefully. An appeal attacks the outcome. You're saying the judge got the facts or the law wrong, so the verdict or sentence should be changed. A review, on the other hand, attacks the process. You're saying something went wrong with how the trial was run. It wasn't fair. And for both, remember, it is not a second trial, so no new evidence is introduced. And that's the entire journey, from a simple report to a final appeal. Every single step is guided by these rules. The whole system is designed to balance the power of the state with the rights of the individual. But it leaves us with that one massive question. How do we make sure this roadmap always leads to the right destination, to true justice for everyone? And that's what makes understanding this entire map so incredibly vital.